in the, in the early 1800s and even in the mid 1800s, the judiciary was seen as the least dangerous branch of government.
Yep.
And I think that the judiciary has now become one of the most active branches in the entirety of government. I think it's grown beyond what our founding fathers had ever envisioned as far as getting involved in. Welcome to the Republic Podcast, where history meets scrutiny and facts matter. Join Rob and Lou as they dive deep into the foundations of American democracy, dissect the laws that shape our lives, and challenge the narratives behind today's headlines. From forgotten chapters in the U.S. history to the legal truths they didn't teach you in school. This is your front row seat to get informed, unapologetic conversation. We have an American republic, if we can keep it. Now, let's get started. And 1, 2, 3. That's what we're covering today. Article 3.
Article 3, baby.
Cheers, Rob.
Cheers to you. Lou, love you.
Here's everyone out there. Thank you all for joining us one more time on the Republic, if you can keep it, podcast.
Absolutely. We are on the Magical Mystery Tour covering the foundational documents of this country because we want everyone to be proud of this country. We want people to have faith in this country. We want people to understanding what makes this country tick, how it came about, and all those things that started way back in the 1700s still apply today.
Still apply, still work. And, we are still on our discussion of the U.S. Constitution, the founding document that created our country and set up the law, set up the rules, and the way in which the country would be set up and governed.
So we've done Article 1,
yeah,
which talked about the legislative, the powers that were given to the legislature. Article 2, the executive branch. And today, Article 3.
Article 3,
which
the
is
judiciary, which
yes.
is one which, again, has been hotly contested over the past, I want to say, over the past 20 years, really. A lot of different things going into it, a lot of different discussions as far as, how many justices should be on it, how, the authority of various courts. There's a lot of different things that come into play. A lot of the questions regarding the authority. What is the original authority of the court? What are the authority of the lower courts, which is something that we'll discuss, which really the authority of the lower courts was not included in Article 3. The only thing that in Article 3 included was the establishment of the Supreme Court, and that's it. And everything else is statutorily created. But before I digress, let's go into the language and what the discussion of what actually Article 3 is.
There we go. And we have 3 sections to Article 3.
3, magic number.
3 is a magic number. Again, for those of you who have no idea, about Schoolhouse Rock, find it, listen to it, have your kids listen to it.
There you go.
You've got to. Anyway, Section 1, yep. Article 3, Section 1 really only talks about 2 things, and it's relatively brief. They talk about the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may deem from time to time to ordain and establish. So, we have the Supreme Court, as we all know, in Washington, D.C., which now has 9 justices. And there are 2 lower tiers. There are other federal courts. There's immigration courts. There's different tax courts. There's different bankruptcy courts. But the general hierarchy of federal courts in this country, as ordained and established by the Congress, we have district courts, which are the trial courts at the lower level where cases are first heard. If someone doesn't like the result, they can appeal it to the Court of Appeals. And there are 11 circuits?
Yes.
I believe so. I was saying we're going to double check that but it's off the top of my head. There are, I believe, 11 federal circuits, which are different geographical regions around the country, so that the district courts in those particular regions go into appellate courts for those particular districts, those circuits. And if someone at the circuit level doesn't like the result from the circuit judges or the circuit decision, they can then appeal to the Supreme Court. Now, the Supreme Court does not have to take the case, which many people don't understand. When you are appealing from the district court to the appellate court, you have a right to have your case heard on appeal. But from all of those different cases that funnel to the different circuits to go to one Supreme Court, the Supreme Court would be overrun with cases if they heard every single one that was appealed to them. So
Right.
they have what's called certiorari, and I know I butcher that every time I try to say it.
Got it. But that was good. You did actually said it.
Thank you. Well, I call it cert. And the Supreme Court can either accept hearing the case or decline it. And if it's declined, the last order from the appellate court at the circuit level, that stands. But if you get to have your case heard at the Supreme Court, and if, by the way, if anyone is around the Washington, D.C. when the Supreme Court is in session,
Awesome.
do yourself the favor. It's a civics lesson in and of itself to go and watch. It's open to the public. There are a limited number of seats, so depending on the type of case, something that has national significance, whether it's a First Amendment, a free speech case, if it's a gun rights case, if it's a search and seizure case, those cases often get a lot of publicity, and there are a lot of people come to watch. Some other cases don't get the publicity, but still, it is such an amazing experience to watch the court in action. Anyway, we'll get off on another thing. Go ahead.
So I did check, and yes, I mean, both of us knew that there were 11 circuit courts, none of the circuit courts. But if you really want to include all of them, there are 13 overall circuit courts. There's 11 numbered courts, and what we mean by 11 numbered courts is that each state has a district court or number of district courts.
Right.
Depending on how large the state is, it can be broken up into several different districts. Like New York is broken up into 4 different districts. Connecticut has 1. Right. Massachusetts has 1. But depending on the size of the state, you could have several district courts. But then you have a number of states that comprise each numbered regional court. So you have the first district, which covers basically from Maine all the way down to Massachusetts. You have the second district, which is New York over. Third district, fifth district covers Louisiana in that area. So a ninth district covers California in that area. So each one of them. Then you have the District Court of Columbia, District of Columbia Court, which was established in 1982, which has high-profile administrative and regulatory cases. So that's basically dealing with issues directly arising out of Congress. And then you have the Federal Circuit, which is specialized, which deals with other certain specialized appeals. But so there are 11. So you have 1 Supreme Court, 11 circuit courts, and then you have the other district courts and specialized courts.
Right.
So there you go.
There you go. But in Section 1, we talk about that. We talk about the Supreme Court and any other lower courts that may be ordained. And the last part of Section 1 is the fact that Supreme Court justices have lifetime appointment. And this is a hot button issue, oftentimes back and forth. I happen to be a very big proponent of lifetime appointment for federal judges because it ensures, as much as you can, judicial independence. You're not tied to worrying about getting a vote. You're not tied to some political party or some movement or whatever it might be. You are there appointed. and you are there to administer the law. That's it.
Right.
So,
I mean, just a sort of momentary tangent on that whole thing, the issue regarding uh, the appointment versus election. Having been in several different states, primarily with New York, which is strictly elected,
yep,
and Connecticut, which is strictly appointed, both have their pros and cons.
right,
With the elections, you're swaying to the beck and call of your constituents of the electoral, and that I don't want to say that decisions have been based upon elections, but decisions have been based upon elections. For appointments, that Connecticut has essentially an appointment where that you were appointed for 8 years and you go up for reappointment every 8 years, unless you do something really stupid. And even I've even seen judges do something really stupid, still get reappointed. Um, the problem with that is though
never
is that
happened.
yeah,
Never
sometimes you
happened.
get judges that are really bad judges, but they get pushed along because of it was a political appointment.
Hmm.
So, you have the pros and cons for each, but going back for the federal courts, from district all the way up to the Supreme, it is a lifetime appointment, period, end of story.
Yep. Now you'll notice in section 1 of Article 3, there are no requirements for people to serve as federal judges. Doesn't say about ages, doesn't say your nationality, doesn't say if you have a criminal record or not, whether you're a lawyer.
Right.
It doesn't say it. So anyone technically can be put forth as a nominee, whether you survive the advice and and
Consent
scrutiny of the
of
Senate
Senate.
is something else. But strangely enough, there's nothing there about requirements. Just saying.
Right. And just doing a quick historical dive on it, that although there have all Supreme Court justices have been have been lawyers, there have been a number who never actually graduated law school, and that they went the apprenticeship route when there was if there was allowed within their state, and then went on to be appointed. So including one of the biggest justices is John Marshall, who made some great decisions back in the early 1800s, but that he only studied law briefly, never actually got his degree, and was apprenticed, that he primarily apprenticed and learned it by going into court and learning how things happen in court and practicing under another attorney.
Right.
There we go. So
Very cool. On to section 2. Section 2 talks about the jurisdiction the court has over cases. And if just to distill it, any case regarding a federal statute or a federal law can go into federal court and ultimately can wind up at the Supreme Court. Cases, there are only 2 sets of cases that can wind up as original jurisdiction that start and finish at the Supreme Court. And those are cases that involve ambassadors and public ministers and consuls, and also when states are a party to, states suing a state. So
right.
North Carolina versus Georgia, whatever. Georgia and I believe Florida had a number of times where
Right.
they wound up at the Supreme Court because they're arguing over the boundary. And the case was filed in and started and ended at the Supreme Court. Those are the only ones that start there. But the other bit of jurisdiction for federal courts was about judicial review. And this was the famous case of Marbury versus Madison back in 1803, which ultimately the case said, look, it doesn't say so necessarily in Article 3 in Section 2 that this is part of our jurisdiction, but we're going to consider this an implied power. And that is, we can review actions of the executive branch and the legislative branch to say if they're constitutional or not. And that has been the law since 1803.
Right. And a lot of it comes down to what's known as a federal question issue.
Right.
Where if there's a question regarding a federal question that has to do not with just a federal statute, but the interpretation of the U.S. Constitution, then that's something that the Supreme Court can take up. And where you'll see is that, if it's something involving the federal, again, one of the federal branches, the, the executive branch, or like, even with Congress or something like that, of course, that's going to come up, that's something that the Supreme Court has jurisdiction over as part of that federal question. But then what you'll see is most often you'll have cases that come up, work their ways up through state courts, and then yet appeal to the U.S. Supreme Court, not based upon the interpretation of a state law, but by the claim that there's a federal question that directly affects a person's U.S. constitutional rights. And I mean, one of during my career, I actually had two cases that were actually appealed up to the U.S. Supreme Court. Both were denied cert, but for various reasons. But what the question was, it was as a criminal prosecution, they were saying that although, and they went all the way where they worked their ways all the way up through the state Supreme Court, the Connecticut Supreme Court, and the Connecticut Supreme Court issued a decision. And then they appealed it to the U.S. Supreme Court saying, yes, although that this is something that the state court decided on a state constitutional issue, we are saying that there is a greater federal constitutional issue that's being affected here, that we're asking the U.S. Supreme Court to take a look to see if the way that the state Supreme Court interpreted this state law, that we're saying that this state law and the way that it was interpreted violates one of my federal constitutional rights.
Right.
So that's a way that it can work its way up through, actually, because a lot of people are like, well, that's a state case. How can that get appealed up to the U.S. Supreme Court? Or, oh, I'm going to appeal this all the way up to the U.S. Supreme Court. Well, good luck, buddy. You got to wind your way all the way through the state courts and then pray to God that you hit a Hail Mary blindfolded in hurricane winds with the lights off.
Right.
But, so
now I'll tell you, we're going to have a really, really, really good rant session about Article 3.
we are.
Because
Okay.
we're going to talk about all these cases that whenever there's something that a president puts forward as an action, people rush to the courts and want injunctions done, or this done, or that done.
Oh, yeah. Oh, yeah.
Article 3. Do the courts have the jurisdiction to do something that's just what's before them, or do their cases have nationwide power and breadth? Well, no.
Especially
We're going to talk about that during the rant.
Right.
There's some talk in the last administration. Now, we're recording this toward the end of 2025, so Trump's in right now. But when Joe Biden was in, there were a number of people who were talking about expanding the Supreme Court from 9 justices. There were talks about expanding it to 13, 15, having 2 different Supreme Courts. I don't know how they do that. One to hear certain criminal cases, one to hear civil. I don't know. As we were talking about, and we've talked about in different times in different sessions, it really is interesting. We knew this anyway, but as we go, Lou and I go through this stuff, and we get to these different amendments and these different sections and these different articles, and we realize everyday news and articles that come out are impacted by what we're talking about here.
Right.
In this particular podcast, The Republic, if you can keep it, remember, tell your friends. All these things, subscribe, all these things come about all the time. And people just, in the public, in my particular view and opinion, I see people, they don't even reflect on it. They don't even know there's a constitutional issue or where it comes from. And this is why we're here. This is why we're doing this.
I mean, yeah, and it's really where, you would think Article 3, there really isn't a big issue. I mean, Supreme Court, what is it? But it's something that is really big, and the jurisdiction of the court is something that's really, and the lower level courts is something that's really there's a built-in dichotomy and built-in friction between all the branches. between Article 1 and the legislature and the president.
Yep.
There's a built-in friction. It's intentionally built inside there. In fact, Article 1, as we've talked about before, there's a built-in friction between between the House of Representatives and the Senate.
Yep.
There's friction there. It was built in that way because they wanted things to go slow and methodically. You have
And
a
be
built-in
deliberative, right?
right. Then you have a built-in friction between the legislative branch and the executive branch and the president. And where do the president powers and there's friction between that. And then you have the friction between the president and the judiciary. And that's all built in and that's all planned because that's how forward thinking our forefathers were.
Checks and balances.
Right.
And it, like, as Lou said, it was, and we've said before, it's baked into the bread in this country. The idea that people need to talk, deliberate, consider different paths, different thoughts, different policies, different whatever. All of the branches are interconnected. There are checks and balances, which you've heard the phrase, but it really is applicable. It's every day there is something that is going on that affects you, affects us, affects the nation, that are from these articles and sections and amendments that we're going over. You may think it's dry and dull and this and that. Every day there's something that comes up that you're like, Rob and Lou were talking about that last week. Bingo.
Right. So, and then, then we have going on to Section 3. So we've talked about Section 2. We've talked about Section 1, the makeup of the court.
Yep.
Section 2, we've talked about the jurisdiction of the court.
Mm-hmm.
Section 3, now we talk about the only other thing that the Supreme Court really has to deal with is the issue of treason. And that it's something that really is, difficult to sort of explain as far as how the Supreme Court is tied up in the issue of treason, but it's really not.
But also remember, the Constitution was drafted in 1787, or at least sent out for ratification in 1787, right? It's close on the heels of the American Revolution. And there were loyalists still amongst the colonists. There was still buzz about people like, I don't know, Benedict Arnold. There were still people who were worried about the loyalists who were trying to undermine the new republic. So things like treason were very, very much in the minds of
very real
the lawmakers. We just created this country, goddammit. We don't want to see it get undermined and tossed in the trash. So Section 3 talks about treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. You've heard that phrase before in recent years. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. But they delegate then from there, Congress shall have power to declare the punishment of treason. But Article 3 of the judiciary in the first part of Section 3 will have the right to deal with treasonous acts against the United States. It is a federal crime. So it goes into the federal court system.
But that is really the only place that you will ever find something specifically defined and enumerated within the Constitution. It says specifically treason. This is the definition, and this is how that it's up to you how it's punished. But this is a crime, and it was that significant, and that it was that near and dear to them, where and such a concern that they felt it was that important to include specifically as an article, as a provision under Article 3, outlining the powers of the judiciary. I think that one of the things is that I really sort of look back and laugh about, and we'll discuss about this more in the rant session as well, is how back in the early 1800s and even in the mid 1800s, the judiciary was seen as the least dangerous branch of government.
Yep.
And I think that the judiciary has now become one of the most active branches in the entirety of government. I think it's grown beyond what our founding fathers had ever envisioned as far as getting involved in. But
And it gets
again, that's
to the
something
same
else.
argument that we talked about last week in Article 2 in our rant session. We talked about the executive orders. When you had certain presidents who said, hey, if it doesn't say I can't do it, I'm going to do it, versus the presidents who were the constitutionalists and say, whoa, 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 I can only do what's been given to me. And so we have the same concern here in Article 3 with some judges and the way
Activist
the
judges.
judges, whether district court, whether whatever level, people, you hear the phrase, oh, that was an activist judge or a radical judge. Well, what does that mean? Are they doing something illegal? No, they never say that. They said there's some people who do things, judges, because it says like it's in that gray area where I say I can't. And there are other judges who are the constitutionalists who say, whoa, 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 I can only do this prospective thing about a case in controversy that comes to me, and that's all I can look at. So again, foreshadowing the rant session next week.
Yep. Bring a lot of this along because it's going to be interesting. Two lawyers arguing about law and the courts. So
I think we have enough of that. We can bring a couple of bottles. It's all good.
Jesus. Oh my goodness. So that's Article 3 in a nutshell. I mean, really, it's not a lot to it. It's
But a lot to it.
But there is a lot to it.
Right.
That this is one where when the Constitution was passed, it gave Congress a large authority to essentially create a separate branch of government. All that's required is the Supreme Court and inferior courts as Congress may feel is necessary. That and that's something where, again, Congress ran with it and created the rules and created the laws that set forth the lower courts and their jurisdiction, and even restrictions upon what the Supreme Court could hear and address. That were absolutely been found to be constitutional restrictions because they were not specifically enumerated in Article 3. There you have it.
And there you have it. So until next week, when you hear our rant session, which will be good, subscribe,
and share. It's most important to share. We and comment. Please let us know. We always finish off with that. But please let us know what you like, what you don't like, and what you'd like us to hear, or what you'd like to hear from us.
Right.
We'll hear from us all the time.
I was going to hear from us a lot, but ask the questions. Ask us, if there are things you want us to cover. Ask if there are things that we have covered and you say, I have a question about this. We'll get to it. We want to understand what the questions that you guys have so we can be interactive with it. If there are things you want us to cover, we'll get to it. We're going to talk about. This is a long, we have 250 years worth of history, but we're starting with the foundational documents. We're going to get to history. We're going to get to the people that made it happen. We're going to get to the events, et cetera, et cetera. This is going to be a long conversation. So bring a bottle of water, bourbon, single malt, rye, soda. I don't care what you want, but make yourself comfortable. We're going to be and we're going to have fun doing it.
Sweet. Until next time, thank you very much. This is the Republic, If You Can Keep It podcast. Cheers, brother.
Cheers.
Cheers, all of you out there. Love you guys. Talk to you.
Cheers.
Cheers.
Shut up and sit down.
Thanks for listening to the Republic, If You Can Keep It podcast. Join Rob and Lou in our next episode as we continue our riveting discussions on the most important topics affecting our great republic. Drop a line for topics you want to discuss, and don't forget to like, subscribe, and share. Until next time.